Oklahoma has a landlord-friendly tenant screening environment with minimal state-level regulation beyond the federal baseline. The state's regulatory philosophy strongly favors property rights and gives landlords broad discretion in how they screen and select tenants. The governing framework includes the Oklahoma Residential Landlord and Tenant Act, found in Oklahoma Statutes Title 41, along with FCRA and the Oklahoma Fair Housing Act. Let's start with application fees. Oklahoma does not cap application fees. There is no state statute limiting what a landlord can charge an applicant for tenant screening. The Oklahoma Residential Landlord and Tenant Act does not address application fee amounts, procedures, or refund requirements. Landlords can charge whatever they determine is reasonable to cover screening costs. While there's no legal cap, most Oklahoma landlords charge between $20 and $40 per applicant, consistent with the actual cost of comprehensive screening reports. Oklahoma's rental market is affordable relative to national averages, and charging excessive screening fees can discourage qualified applicants in a market where rents are moderate. Criminal history screening in Oklahoma is unrestricted at the state level. Oklahoma does not have a ban-the-box or fair chance housing law for housing. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history as a screening factor without conducting a formal individualized assessment, and are not subject to state-mandated look-back period limits. No Oklahoma municipality has enacted local criminal history screening restrictions for housing. Oklahoma City, Tulsa, Norman, Broken Arrow, and every other Oklahoma community operate under the same unrestricted framework. However, Oklahoma has enacted significant criminal justice reform in recent years that affects the screening context. In 2016, Oklahoma voters approved State Questions 780 and 781, which reclassified several nonviolent felonies as misdemeanors, including simple drug possession and certain low-level property crimes. This reclassification means that offenses that were previously felonies on an applicant's record may now be classified as misdemeanors. Landlords should be aware that Oklahoma's criminal classification landscape has shifted, and offenses that appear on older records as felonies may have been reclassified. Oklahoma also expanded its expungement provisions in recent years, making more offenses eligible for record sealing. Landlords cannot consider expunged records in screening decisions. If an applicant's record has been expunged under Oklahoma law, it should not appear on a screening report. But landlords should verify that their screening provider is current with Oklahoma's expungement statutes. HUD's 2016 guidance on criminal history and disparate impact applies in Oklahoma. While Oklahoma's legal culture is generally favorable to landlord rights, the federal framework governs. Blanket policies that reject every applicant with any criminal record can violate the Fair Housing Act if they disproportionately affect protected classes without legitimate business justification. Oklahoma has a significant Native American population, with 39 federally recognized tribes and substantial tribal jurisdiction across the state, and criminal history policies that disproportionately affect Native American applicants may face particular scrutiny under federal fair housing law. Source of income protection does not exist at the state level in Oklahoma. Landlords are not prohibited from considering the source of an applicant's income when making screening decisions. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. No Oklahoma municipality has enacted a local source of income protection ordinance. Participation in voucher programs is entirely voluntary. For credit reports, Oklahoma follows standard FCRA requirements, permissible purpose, written consent, and adverse action notice procedures. Oklahoma does not impose additional state-level requirements for credit report access, adverse action content, or notification timelines beyond the federal baseline. Oklahoma's fair housing protections are found in the Oklahoma Fair Housing Act, Oklahoma Statutes Title 25, Section 1451 and following. The Act prohibits discrimination in housing based on race, color, religion, national origin, sex, disability, and familial status, mirroring the Federal Fair Housing Act. Oklahoma has not added additional protected categories such as sexual orientation, gender identity, marital status, age, or source of income beyond the federal baseline. The Oklahoma Human Rights Commission, operating under the Office of the Attorney General, investigates fair housing complaints. One notable aspect of Oklahoma's legal framework that affects tenant screening is the state's significant tribal jurisdiction. Much of Oklahoma falls within tribal jurisdictional boundaries, and properties on tribal land or within tribal jurisdiction may be subject to tribal housing laws and regulations that differ from state law. Landlords who own rental property on tribal land should consult with an attorney familiar with tribal housing law to understand any additional requirements that may apply to the screening process. From a practical standpoint, Oklahoma has an affordable rental market with moderate demand concentrated in two major metros. Oklahoma City, the state capital and largest city, has the state's strongest rental market. The economy is driven by energy. Oklahoma City is a major center for oil and gas operations, aerospace and defense, including Tinker Air Force Base, one of the largest Air Force installations in the country, healthcare, government, and a growing technology and bioscience sector. The Oklahoma City Metro, including Edmond, Norman, Moore, Midwest City, and Del City, has seen moderate rent increases driven by population growth and economic diversification. Tinker Air Force Base is a massive employer in the Oklahoma City metro and generates substantial military rental demand. Military tenants represent a significant portion of the Midwest City and Del City rental markets. Landlords near Tinker should understand military income documentation, leave and earnings statements, BAH rates, and the Service Members Civil Relief Act. BAH rates for the Oklahoma City area are moderate and directly influence rental pricing near the base. Fort Sill, near Lawton in southwestern Oklahoma, is the Army's primary fires training center and generates significant rental demand in the Lawton-Fort Sill area. The military rental market in Lawton is heavily dependent on Fort Sill's operational tempo, and BAH rates drive pricing for a large portion of the community's rental units. Landlords in the Lawton area who don't understand military income documentation are at a disadvantage in serving this market. Altus Air Force Base near Altus and Vance, Air Force Base near Enid, also generate military rental demand in their respective communities, though on a smaller scale than Tinker and Fort Sill. Tulsa, Oklahoma's second largest city, has a moderate rental market driven by energy, aerospace, including American Airlines' massive maintenance facility, healthcare, manufacturing, and a growing remote worker economy fueled by the Tulsa Remote Program, which pays remote workers to relocate to Tulsa. The Tulsa Remote Program has attracted thousands of new residents and has been particularly successful in attracting younger, tech-oriented renters. Landlords in Tulsa may encounter applicants from across the country who have relocated through this program. Screening these applicants requires verifying out-of-state employment and rental history. Norman, home to the University of Oklahoma, has a tight, student-driven market. OU's large enrollment creates strong seasonal demand and high turnover. Screening students with limited credit and rental history is routine, and having a consistent cosigner or guarantor policy is essential. Stillwater, home to Oklahoma State University, has a similar dynamic. Broken Arrow, Owasso, and Bixby in the Tulsa suburbs have growing family-oriented markets. Shawnee, Bartlesville, Muskogee, and other mid-size Oklahoma communities have more affordable markets with limited applicant pools. Oklahoma's energy economy creates cyclical dynamics that affect the rental market. When oil and gas prices are high, communities in the energy corridor, including areas around Oklahoma City, the Scoop and Stack plays in central Oklahoma, and western Oklahoma, see increased demand from energy workers. When prices drop, demand softens. Landlords in energy-dependent communities should understand these cycles and calibrate their screening standards accordingly, tightening criteria when demand is strong and being more flexible when the market softens. One best practice for Oklahoma landlords, even though the state imposes virtually no screening restrictions, develop a written screening policy that documents every criterion you apply. Specify your credit score threshold, income-to-rent ratio, rental history requirements, criminal history evaluation standards, and how you handle applicants with limited credit history. Apply those criteria to every applicant uniformly. The absence of state regulation doesn't eliminate federal fair housing obligations. Another best practice: verify that your screening provider is current with Oklahoma's criminal justice reforms, including the reclassification of certain felonies to misdemeanors under state questions 780 and 781 and the expanded expungement provisions. Your provider should be returning records that reflect current classifications, not outdated felony designations for offenses that have been reclassified. If your provider's data is outdated, you risk making screening decisions based on inaccurate information. A third best practice: for landlords near military installations, develop a standardized military screening checklist. Military applicants present the most verifiable and predictable income of any applicant type. The leave and earnings statement shows exact pay, BAH is guaranteed, and employment stability is generally excellent. Understanding military income documentation streamlines your screening and ensures you're evaluating military applicants accurately and consistently. Oklahoma limits the security deposit to an amount agreed upon by the landlord and tenant. There is no statutory cap. However, the landlord must hold the deposit in an escrow account at a federally insured financial institution in Oklahoma. The deposit must be returned within 45 days of the tenant vacating. While the flexibility on deposit amounts provides financial protection, thorough screening remains the most cost-effective tool for avoiding problem tenants. For the complete guide to Oklahoma tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.